Imagine you own a cargo ship worth millions of dollars. Your vessel is fully loaded, your crew is ready, and your cargo is scheduled for delivery. Every passing hour costs you $1,000. Then, just before your ship departs, you are told that it will not be allowed to sail unless you make a payment to a union's welfare fund. At the moment, what would you do? Would you refuse and suffer devastating financial losses? Or would you pay, not because you wanted to, but because you had no realistic alternative? If you choose the second option, did you really consent? That simple question lies at the most influential cases in contract law. Universe Steamship Incorporated of Monrovia against International Transport Workers Federation or ITF. This case transformed the law on economic duress by challenging one of the most fundamental principles of contract law, that agreements are founded on free and voluntary consent. With that in mind, let us begin by examining the facts of the case and its procedural history. Universe Steamship Incorporated owned a vessel called the Universe Sentinel. On 17 July 1978, the vessel arrived at Milford Haven, a major port in Wales, to load cargo. However, it did not have an ITF Blue certificate. Basically, this certificate showed that the ship complied with the ITF's employment standards for seafarers. Because the ship didn't have one, the ITF initiated LAC, meaning that the union members refused to provide services to the ship. In this case, no tugboats were willing to assist the Universe Sentinel, so the vessel could not leave the port unless the owners agreed to its demands. ITF required the owners to pay $80,000 in back pay for the crew and another $6,480 to their Special Seafarers Fund. On top of that, the owners also had to sign a special agreement. Only after these conditions were met, the ship allowed to continue its journey. Since every delay meant more financial losses, the owners decided to pay the money under protest so the ship could leave the port. Soon after, the owners instructed their solicitors to recover the money, arguing that the payment had been made under economic duress. As the case moved forward, the owners withdrew their claim for the back wages, so the remaining issue was the $6,480 payment made to the ITF welfare fund. At the High Court, the judge found in favor of the ship owners. The court held that the payment was made under economic duress because the owners had no real choice but to pay in order to release the ship. Therefore, they were entitled to recover the money. However, the ITF appealed to the Court of Appeal. They argued that their blocking action against the vessel was lawful and protected under trade union legislation. They also argued that the payment made to the welfare fund was simply a valid payment, not a trust arrangement, and therefore it should not be returned. The Court of Appeal then allowed the ITF's appeal and overturned the High Court decision, meaning that the ship owners could not recover the money. The ship owners then appealed to the House of Lords to restore their original claim, which is the ITF's pressure had forced them into making the payment.
Next, I will be presenting on the court analysis of this case. The first issue was whether the $6,480 payment made to the ITF welfare fund was held under a trust. The ship owner argued that the money was paid for a trust purpose, and because the trust was invalid, the money should be returned back. However, the court had to decide whether the welfare fund was really a trust or just a fund managed by the ITF. The second issue was whether the payment was made under the economic duress. The ship owner argued that they were forced to make the payment because the ITF had stopped the ship from leaving the port. Since the ship was unable to continue the journey, the ship owner claimed that they had no any other choice except to agree to the ITF demands. The third issue was whether the payment to the welfare fund was related to the term and condition of employment under Section 29 of the Trade Union and Labour Relations Act 1974. This issue was important because if it was considered as a trade dispute, the ITF action would be protected by law. However, if it was not a trade dispute, the pressure used by the ITF could be considered as unlawful. Next, for the ratio decidendi, the House of Lords first decided that the ITF welfare fund was not a trust. It was only a fund belonging to the ITF and managed according to their own rules. Therefore, the ship owner could not recover the money based on the trust argument. However, the court found that the payment was made under economic duress. The court recognized that the economic pressure can become duress when a person has no practical choice but to submit it. In this case, the ship owner was facing serious financial loss because the ship was detained and could not leave the port. Therefore, they had no any other option except to make the payment. And the court also decided that the contribution to the ITF welfare fund was not part of the crew terms and conditions of the employment. It was different from wages, benefits, and union membership fees because it was not a direct benefit included in the employment relationship. Because of this, the payment was not considered part of a protected trade dispute under Section 29. Therefore, the ITF could not rely on the legal protection for the pressure applied by them against the ship owner. And lastly, the decision of the court. The House of Lords allowed the appeal by the ship owner. Even though the ship owner failed on the trust issue, they still succeed on the issue of economic duress, and the court ordered to the ITF to return back the money, which is $6,480 that paid into the welfare fund because the payment was made under the illegitimate economic pressure. And this case also important because it shows that economic pressure can amount to duress when a person is left with no practical choice, and money paid under such pressure can...
For the second case is the case of the LAC and another against one UV and others. The plaintiff is LAC and another were the partners in the business of the FAVE enterprise, which is a partnership business possessing the valuable timber logging rights. The defendant is one UV and others negotiated to acquire the business. To complete the acquisition, they incorporate and use the Centennial Asia Sedia Berhad, a dormant company in which they were the directors, as the purchaser under the Sale and Purchase Agreement SPA. The defendant also controlled another company, which is the West Hill Equity Sedia Berhad Company, which paid the first two installments of the purchase price. Fact of the case. On 11 January 2013, the plaintiff signed the SPA to sell their partnership business, namely FAVE, to the Centennial Asia Sedia Berhad Company for RM7 million. This purchase price was paid in 3 installments. First is RM2 million upon signing the SPA. Second is the RM2.5 million within 60 days. And third is RM2.5 million within 90 days. After the SPA was signed, the plaintiff transferred the ownership of the FAVE company to the first and the second defendant directly, not to the Centennial company. Therefore, the first and the second defendant become the new partner of FAVE company. As for the payment, the first 2 installments totaling RM4.5 million were not paid by the Centennial. Instead, the payment were made by the West Hill Equity Sedia Berhad Company, so controlled by the defendant, although the company is not a party to the SPA. However, the final installment of the RM2.5 million were never paid by the Centennial. This failure led the plaintiff to file the suit 128 to claim the balance of the purchase price. In the suit, Centennial Company alleged that the plaintiff had misrepresented, namely giving a false representation of the profit of the logging rights. However, the High Court held that the plaintiff were successful in their claim and dismissed the Centennial counterclaim. Since Centennial was merely a company with no asset or fund to pay the debt, in 2018, the plaintiff filed another action under the section of 540 of the Companies Act 2016 against the defendant personally. The purpose of this action was to obtain a court order that the defendant be personally liable for the company's debt for allegedly conducting business in fraudulent trading or trading by deception. Procedural history. At the High Court for the suit 128, the appellant, who were the partner of the FAVE, sued the Centennial Company for the specific performance and the payment of the final RM2.5 million purchase price under SPA. The Centennial Company responded by alleging the misrepresentation regarding the timber logging rights and the project profits. However, the High Court allowed the appellant's claim and dismissed the Centennial counterclaim after a full trial, and no appeal was filed against this decision. Centennial did not appeal this decision but failed to pay the judgment debt. Following the Centennial failure to pay the judgment debt, the appellant initiated a second High Court action under the Section 540 of the Companies Act 2016 against the company director and shareholder, seeking to hold them personally liable for the fraudulent trading. The respondent raised the same allegation of misrepresentation rejected in Suit 128, arguing they had a legitimate commercial reason for non-payment. The High Court dismissed this claim, holding that the element of the intent to defraud was not proven and the res judicata did not apply as the cause of between two suits were different. Then, the appellant appealed the dismissal of the Section 540 suit. On the appeal, Court of Appeal upheld the High Court decision, agreeing that the res judicata was inapplicable and the misrepresentation issue could still be raised by the respondent. Finally, at the Federal Court, the appellant were granted leave to appeal to the Federal Court on the three specific questions of law regarding to the director liability under the Section 540 res judicata and the commercial presumption of good faith. The Federal Court allowed the appeal, overturning the decision of the Court of Appeal and the High Court. It held that the respondents were barred by the res judicata from relitigating the issue of the misrepresentation and that their conduct amount to the fraudulent trading, making them personally liable for the debt.
Next, for the legal issues. Question 1 is whether company directors are ipso facto liable to a vendor under Section 540 of the Companies Act 2016 if the vendor immediately transfers an asset to the company relying on future payments and the company subsequently defaults. Question 2 is a director sued under Section 540 barred by the res judicata or issue estoppel from asserting defences that were already unsuccessfully raised and dismissed by the company in a previous suit? And may such a director legally assert that the company had a legitimate commercial reason not to pay the balance purchase price despite the prior judgment? And the question 3 is the English Supreme Court principle Takhar against Gracefield Developments Limited, stating that the law does not expect people to arrange their affairs on the basis that other people may commit fraud, representative of Malaysian law. For the ratio decidendi, first, the intent to defraud is established if the directors hide behind a dormant company with no assets to escape personal liability while had obtained all the benefits of the sale and purchase agreement. Second, the defendants were barred by res judicata from arguing the same misrepresentation defense because that issue had already been decided against them in Suit 128. The court treated the earlier High Court ruling as conclusive since Centennial did not appeal it, so the same issues could not be reopened in the later proceedings. The third one, the law does not require parties to protect themselves against a risk that the other party may commit fraud when they have voluntarily entered the SPA with knowledge of the counterparty's position and financial standing. Lastly, for the orders, the appeal is unanimously allowed with cause, and the orders of the High Court and Court of Appeal are set aside.
As the final speaker, my role is to summarize what our group has discussed about these two important cases. At first, these two important cases very different. In Universe Township of Monrovia against International Transport Workers Federation, it is about economic duress or coercion in a labor dispute, while in LAC and another against WU and others is about company misrepresentation. However, these both cases have the same legal purpose, which is to protect business from unfair and dishonest conduct. In Universe Townships, the House of Lords drew a firm line against illegitimate pressure, ruling that when a party's choice is entirely vitiated by catastrophic economic coercion, the law will compel restitution of the funds. Similarly, in the case of Levy, the Malaysian Federal Court looked post-corporate technicalities to rule that directors cannot hide behind a dormant assetless company to intentionally defraud vendors. In conclusion, these two cases show that contract law is based on free consent, honesty, and fairness. Whether someone forces another party into an agreement or tries to escape responsibility through fraud, the courts will focus on what really happened and make sure justice is done.